Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers disorderly conduct, obstruction, and trespassing, and is brought to us by Gonzo Audit's channel. Be sure to check out the description below and give them the credit that they deserve.
Before we dive into the interaction, I want to give everyone a quick reminder to pick up your copy of the Civilian Rights Hand Guide. It's a thorough and comprehensive guide designed to help you understand your rights and navigate encounters with law enforcement confidently. This book is simple, easy to read, and packed with practical advice and real-world insights that anyone can use, whether you're preparing for the unexpected or just want to be better informed. This book covers everything you wish you had been taught in school about how to interact with the police, and puts it into one easily digestible resource. The Civilian Rights Hand Guide is now available as an ebook, and you can even read it for free if you're subscribed to the Kindle Select program. If you've ever found value in the content we create here, then you're going to find this guide incredibly useful. We spent a lot of time making sure that we crafted a book that would genuinely help people understand their rights and what to actually do during and after police interactions. It's available now exclusively on Amazon, and it's a great way to support what we do while arming yourself with knowledge. You can find a link in the description and pinned comment. Thank you for your support. Now, let's get back to the episode.
On December 5th, 2024, First Amendment Auditor William Reynolds went to the Cheektowaga Police Department in Cheektowaga, New York, with his wife Patricia to file a complaint. Ms. Reynolds filmed the encounter that followed, including a long conversation with Sergeant James Rutkowski, and Mr. Reynolds posted it to his Gonzo Audit's YouTube channel.
If you'd like to listen, but I don't think it's going to help because part of it's against Lieutenant Slavatiski.
Okay.
Yeah. So I got a question. Your body cam's on?
Yes, sir.
Okay. Just a question that maybe you could answer, and I just want your opinion on it. I'm a big guy, right?
Okay.
Are you guys allowed to, you guys have to follow the same laws I do. The uniform, that badge doesn't give you extra rights or privileges, right? So if you put your hands on a citizen, a private citizen, without rights or without reason, and nothing is done, the lieutenant, I asked him in the office when he took me back to the other day, I said, if I was to right now get up and shove you in the shoulder like Officer Grant shoved me, what would happen? He told me I would laugh at you. Right then I should have crossed that desk. When we come out this door, I asked him again, what would happen if I put my hands on you? I would laugh at you. About 10 seconds later, now if you like to see the video, I've got it from you. He says, I'd laugh at you for being so stupid for getting arrested. That's entrapment. He also cursed at me. I can't get a lot of your officers to identify. I can't get the name of an officer I filed the complaint on because Hotchkiss says, well, we've put the complaint in, but I'm not going to tell you which of the 3 officers there cursed at you.
Okay.
Even though she knows.
Okay.
I was put on 941 paperwork.
I'm sorry, I'm unaware of
like I said, that's why I'm asking to speak to the captain of the chief.
Okay.
I
can.
I would love for you. All I need from you, because they have an office here, right? You can go speak to them. Let them know William Reynolds is here. He will be here until they come see me.
Okay.
If they don't come see me today, I'll be posting my videos online, and you guys can deal with the complaints and calls that you will get.
Okay.
Because, like I said, your lieutenant cursed at me, tried to entrap me. Like I said, there's just a ton of stuff. So if you want to go either tell the chief or the captain, William Reynolds is going to be sitting in your lobby. He will talk to every person that comes in.
Okay.
He will video record everything.
I can do a couple things for you. I can. I think they're in an administrative meeting right now. I can leave a message for you. If you'd like, I can direct you to his phone.
You need an answer. I've already called him twice.
Okay.
They don't call me back.
Okay.
That's why I'm in person.
Okay, gotcha.
Because I'm allowed to sit in this lobby and record all I want. I'm allowed to talk to people that come in. I'm allowed to ask your staff things. I'm allowed to record your case. I'm going to ask why I've been pulled over for a plate blocker, for my plate being illegal, my plate holder being illegal.
Okay.
You guys have vehicles out in your private lot with toll blockers, front tinted windows, and he says, well, they're on a private lot, so I'm not going to ticket them. My next thing is I'm going to sit out in a lawn chair waiting for them to leave. I'm going to call 911 every time someone leaves.
Okay.
You guys are going to either hold yourselves accountable or I'm going to do it. You will either be the consequences for yourself or I will be your consequences. It's not going to happen anymore. Your officers are not going to run free doing whatever they want, cursing at people, being... here, let me see you can stop this for a minute. Stop.
Mr. Reynolds argues that a police officer cannot be the victim in a disorderly conduct charge. Under Section 240.20 of the New York Penal Law, one way that an individual can be guilty of disorderly conduct is, quote, when, with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, in a public place, he uses abusive or obscene language, or makes an obscene gesture. As the Supreme Court explained in the 1987 case of City of Houston versus Hill, quote, "The First Amendment protects a significant amount of verbal criticism and challenge directed at police officers." Accordingly, the Second Circuit Court of Appeals, which has jurisdiction over New York, determined in the 1999 case of Poser versus Court Officer Shield number 207 that, quote, "Only so-called fighting words directed at police officers can be criminalized, and the fighting words doctrine is probably narrower in application in cases involving words addressed to a police officer, because a properly trained officer may reasonably be expected to exercise a higher degree of restraint than the average citizen. As a result, provocative speech directed at police officers is protected against censorship or punishment, unless shown likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest." Well, citing this case, among others, the U.S. District Court for the Eastern District of New York held in the 2015 case of Stern versus Shamas that under the New York Disorderly Conduct Statute, quote, "Abusive or obscene language is not unlawful if it is constitutionally protected speech, and with respect to words directed at police officers, language is only unlawful when it contains fighting words that tend to incite an immediate breach of the peace. Consequently, under New York law, police officers can be the so-called victim of a disorderly conduct charge when an individual directs abusive or obscene language at them, but only when the language rises to the level of so-called fighting words, which the Supreme Court defined in the 1942 case of Chaplinsky versus New Hampshire as, quote, "those which by their very utterance inflict injury or tend to incite an immediate breach of the peace." These situations in which a police officer can be the victim of a disorderly conduct charge is further limited by the statute's requirement that an individual act with the intent to cause public inconvenience, annoyance, or alarm, or recklessly create a risk of it. However, there are circumstances where citizens can be convicted of disorderly conduct for directing fighting words at police officers if this so-called public harm element is met. For instance, in the 1997 case of People versus Tishner, the New York Court of Appeals affirmed a disorderly conduct conviction against a citizen who uttered an obscenity at an officer and spat on the ground towards an officer's feet as he walked past a bar, then shoved him while shouting further obscenities. Although the defendant argued that he was wrongfully convicted based on a private so-called tete-a-tete with the officer, the court concluded that the jury had sufficient evidence to conclude that the defendant intended to cause and incite a public disturbance, based on the fact that a number of bar patrons gathered in the doorway to see the commotion, requiring the officer to call for backup and allowing the defendant to slip away and re-enter the bar. Therefore, the New York Disorderly Conduct Statute does allow for a police officer to be the quote-unquote victim of a disorderly conduct charge, as long as the defendant acts with the intent to cause public disorder. Nonetheless, the mere use of profanity or name-calling against an officer without an element of public harm involved would not rise to the level of disorderly conduct.
Like I said, if you want to go tell either Coons or Jarris that it's going to be a long day for them.
Yeah,
it's going to be a long day
I'll
every
pass the
day.
message along. I don't know what's on.
That's all I want. And you don't have to say anything else besides it will be a very long day, or it's going to be a difficult time until they come see me. And,
okay.
And I'll be here until they do, and I'll keep calling, and I'll have other people call on my behalf. They can either stop this now and be men and come out here and talk to me, be adults, and hold their officers accountable for the bad things they do, the lies they tell. I appreciate passing on. I appreciate talking.
Yeah, no
like
problem.
I said, I get. In the long run, you have to protect your department and your job. I get that, and it's not about a personal thing against me. It's just you can't say something whether you believe it or not. You're pretty much playing PR right now, and I get that. We'll let the captain and the chief, we'll let them say their stuff.
Yeah.
When I came in and filed my complaint, I was told by the male officer, I should have gotten his name, He told me that I said I want your officer arrested or charged with disorderly conduct. I'm not going to charge my officer with disorderly conduct. We should have arrested you for like 80 times. Arrest me. I am a First Amendment auditor. I'm sure you know. I'm sure you've heard of Long Island audit. I'm sure you probably know of Dan Warmis auditing here in county.
Yeah, I watch Dan's stuff.
Yeah, I do that stuff too. Though the one that cursed at me, he needs to get a disorderly conduct violation. Do Slavitisky. Interference is physical, correct? And it's physical, right? Interference. If you charge me with interference, it has to be a physical. My words are not interference, right? Me just being there is not interference. Your officer having to take his attention away from his call is not interference.
When you say interference, you mean like a specific a criminal charge?
Yeah.
Okay.
Interfering with an officer's duty or whatever.
Yeah, okay, I apologize.
Yeah, no, that's fine.
Typically it is.
So me just talking and being there, that's interference?
If I can't speak for that situation.
No.
Yeah.
In general, is interference? It literally says in the statute it's a physical act. So why are we going round and round? It says in the statute interference has to be physical.
Yeah.
So that's all I'm asking. Yes or no? Interference has to be physical, right?
I mean, again, we can go hypotheticals all day.
It's not hypothetical. In the statute, does it say it has to be physical?
It doesn't say physical. No. So if you're and interference, let me kind of push on that. That is not a quote unquote charge that we have here. Are you referring to obstruction?
I'm sorry. Yes. That's
okay.
What it is.
Obstruction of governmental administration. Yeah, it could be physical interference. But again, hypotheticals. If I'm trying to investigate a situation, if I have somebody in the middle of the situation who's uninvolved,
you can put up tape. That's the beautiful part.
Screaming. Yep. Could
put
up tape.
You can put up. Let's not use that.
Yeah.
Screaming is your addition. I don't scream at people.
Yeah.
Mr. Reynolds argues that obstruction has to be a physical act, and that citizens have the right to film a traffic stop from anywhere the public can be. According to Section 195.05 of the New York Penal Law, quote, a person is guilty of obstructing governmental administration when he intentionally obstructs, impairs, or perverts the administration of law or other governmental function, or prevents or attempts to prevent a public servant from performing an official function by means of intimidation, physical force or interference, or by means of any independently unlawful act. In the 1977 case of People versus Case, the New York Court of Appeals held that the word physical modifies the word interference as well as the word force, concluding that, quote, mere words alone do not constitute physical force or interference such as to support the charge of obstructing governmental administration, and that, quote, the interference would have to be, in part at least, physical in nature. Applying this precedent, the U.S. District Court for the Eastern District of New York determined in the 2017 case of Charles versus City of New York that there was no evidence for the purposes of the obstruction statute that an individual physically interfered with officers when she repeatedly refused commands to back up from them and, quote-unquote, aggressively videotape directly in an officer's face. Likewise, under Section 79P of the New York Civil Rights Law, quote, a person not under arrest or in the custody of a law enforcement official has the right to record law enforcement activity. Nothing in this subdivision shall be construed to permit a person to engage in actions that physically interfere with law enforcement activity or otherwise constitute a crime defined in the penal law involving obstructing governmental administration. Therefore, under New York law, a court would likely find that individuals can generally film a traffic stop from any distance, as long as they do not physically interfere with the officer's duties, and that they cannot be convicted of obstruction unless their conduct amounts to a physical interference. However, it is important to understand that these state laws protect more filming activity than courts have found the First Amendment to protect. The Charles case we discussed earlier explained that courts have found that the right to film police activity is, now quoting, subject to reasonable time, place, and manner limitations, and that, now quoting again, the right to record police activity in a public space is not without limits and might not exist if the recording interferes with the police activity. The so-called interference referenced in the First Amendment analysis is not limited to physical interference, as with the obstruction statute and the Right to Record Act. And the Charles court found that there was a substantial factual issue regarding whether the plaintiff's filming was interfering with police activity for First Amendment purposes, despite previously concluding that there was, quote-unquote, no evidence that her filming physically interfered with the officers for the purposes of the obstruction statute. Accordingly, it should be noted that there may be instances where a court finds that a citizen's filming activity did not rise to the level of obstruction and is protected by the New York Right to Record Act, but was not protected by the First Amendment because it interfered with police activity in a non-physical way.
I appreciate you, officer.
Yeah,
If you want to go tell the chief and the captain.
William, right?
William.
And then Pat?
Patricia, yeah.
Patricia, I'm sorry.
And let them know
Nice to meet
William
you.
Reynolds. They know who I am. Like guarantee.
Okay, I'll pass the message along.
This will not stop until my needs are met. This will not stop. I can be here every day. I can record. I will protest. Y'all can hold yourself accountable, or I will do it. Like when I ask for an officer for charges to be filed against an officer,
Yeah.
and they tell me they won't do it, I'm asking you to file charges. You're an officer. It's what you do. You don't get to decide whether, I'm not going to do it. I asked you to file charges, right? It should have been done, correct?
I can't speak for that. If you, let me.
As an officer, right now, I am
Yeah.
asking you to file charges against the officer that swore at me for disorderly conduct, and I want charges for disorderly conduct against Officer Slavatitsky for cursing at me in his office.
Yeah. Would I file charges against Lieutenant Swalaticki or that other person? I wouldn't. I would generate a report. I would generate a complaint of some sort. But me personally not being involved in the situation, I would need more proof.
That is your job. You
Yep.
are not the court. You are not the judge. You are not the attorney. You just cite the person. You let them deal with it.
So specifically for disorderly conduct, it being a violation in New York State, unless
Anything that
I
is
guess it
cause
would
to
be-
disturb or alarm. I was
Yeah.
alarmed that he would call me while he is on the job. I am alarmed. I am letting you know the circumstances. I would
Yeah.
like Slavatitsky and I'd like the body cam footage to be seen, and I'd like your other officers cited with disorderly conduct. Just say, we don't need to go back and forth anymore. Are you going to cite them, yes or no?
me personally, I wouldn't review that situation, sir, because I don't think it happened on my shift, number
It doesn't
one.
matter.
Yeah.
You're a police officer.
Yeah.
A statute was broken. I would like Black Chief, who was on today. I know he's on because I saw your paperwork. I want him to come down. He was there. I'd like him to issue the citation
The citation to,
for disorderly conduct against the officer that swore against me. He was there. He saw it happen, right?
Okay.
You saying you can't do it because you weren't there. I'm asking you for the sergeant that was there, that showed up on scene and heard your officer curse at me.
I think with the complaint that you have, if they address that further today with you, I would address it with either Captain Gervais or the Chief of Police, whoever speaks to you.
Okay.
But as far as me filing charges or Sergeant Black Chief filing charges against an officer,
But I'm just going off of you. You gave me a bunch of reasons why you wouldn't or couldn't, and I'm giving you
Yeah.
reasons why that guy can. And they're the exact reasons why you said you couldn't.
I'm not trying to speculate or argue with you.
Me neither. I just want to know that if someone wants to file a disorderly conduct charge with you, that you're telling me because you weren't there, you won't file it. I'm not asking you to be judge, jury, or a lawyer. I'm asking you to file a charge and let the judge and them decide. You have body cam. If it didn't happen, then he walks free, right?
It would definitely go up the
It's
chain.
good to know that no matter what happens, they will not file charges against their officers. They will not hold each other accountable at the time things happen. So, I'm gonna let you go so you can get your call.
Sure.
If you'd let the chief
Yeah,
and or captain
absolutely.
know,
Again,
appreciate it.
nice to talk to you,
being
nice to talk
courteous.
to you, dear.
Hey,
Yeah.
if I got high feet anyway, I get a
That's
little
okay.
emotional about this. So.
It's no problem at all. Happy to talk to you. If there's anything else we can do, let you know. Again, I'll pass the message along. I don't know what their
Just like I
schedule
said,
is
just
today.
let them know I will be here all day,
Okay.
every day until they
All right.
want to talk to me.
Thank you, guys.
Appreciate it.
Have a good day.
Mr. Reynolds asks Sergeant Rutkowski to file a disorderly conduct charge against Lieutenant Slavatitsky, the officer who cursed at him, and Sergeant Rutkowski refuses. Under Section 140.10 of the New York Criminal Procedure Law, a police officer is only authorized to make warrantless arrest or issue appearance tickets for so-called violations, such as disorderly conduct, when they have reasonable cause to believe that such person has committed such offense in their presence. Accordingly, Sergeant Rutkowski would not be legally authorized to arrest or cite Lieutenant Slavatitsky because the altercation did not occur in his presence. And even if Sergeant Rutkowski had witnessed the use of profanity, based on Mr. Reynolds' description of the incident, it is likely that he would not have the probable cause necessary to arrest Lieutenant Slavatitsky or issue a ticket for disorderly conduct. As we discussed earlier in this episode, Section 240.20 of the New York Penal Law states that, quote, a person is guilty of disorderly conduct when, with intent to cause public inconvenience, annoyance, or alarm, or recklessly creating a risk thereof, in a public place, he uses abusive or obscene language or makes an obscene gesture. First, as the U.S. District Court for the Northern District of New York noted in the 2011 case of Potenza versus Gonzalez, quote, the disorderly conduct statute does not circumscribe pure speech directed at an individual. Rather, it is directed at words and utterances coupled with an intent to create a risk of public disorder. A court would likely find that Lieutenant Slavatitsky did not act with intent to cause public disorder during what appeared to be a private dispute with Mr. Reynolds. Additionally, the statute requires that disorderly conduct occur in a so-called public place, which Section 240.00 of the New York Penal Law defines as, quote, a place to which the public or a substantial group of persons has access. Now, because Mr. Reynolds stated that the encounter took place in Lieutenant Slavatitsky's office at the police precinct, which was presumably not open to the public, it seems unlikely that a court would conclude that the speech occurred occurred in a public place. Finally, and arguably most importantly, Lieutenant Slavititsky's speech was likely protected by the First Amendment. As we have discussed many times before here on ATA, the use of profanity is protected by the First Amendment, and the government cannot criminalize the use of such speech unless it rises to the level of so-called fighting words. As the District Court of Nassau County explained in the 2000 case of People versus Levio, quote, "Speech is often abusive, even vulgar, derisive, and provocative, and yet is still constitutionally protected under the state and federal constitutional guarantees of free expression, unless it is much more than that. Unless speech presents clear and present danger of some serious substantive evil, it may neither be forbidden nor penalized. Any prescription of pure speech must be sharply limited to words which, by their utterance alone, inflict injury or tend naturally to evoke immediate violence or other breach of the peace." The court also stated that, quote, "Even if the words are imprudent, thoughtless, tasteless, or just plain angry, so long as they were not legally obscene or fighting words, they are constitutionally protected. Only where words are uttered as a deliberate challenge to a breach of the peace, with communication of thought a mere incidental concomitant, that a prosecution may lie. To pass constitutional muster, the offending words must be calculated to provoke a reasonable person into an immediate and violent breach of the peace, and have no other purpose." Well, considering the strong protections given to speech by the First Amendment, it seems highly likely that a court would conclude that there was no probable cause to believe that Lieutenant Slavititsky had committed disorderly conduct here.
To be clear, I want you to be clear with what's going on with me here. I'm not leaving. I'm not trespassing. I'm broken the law.
What I'm telling you is, if you disrupt the normal operations of our police station, you will be.
How so? How would I be disrupting? Let me know so I don't do it.
If our dispatchers can't sit here and conduct their work with you without you disrupting them,
Wait, hold
then
on.
numbers would be arrested.
Sit there?
Okay? And you need
I didn't disrupt them there. How did I disrupt them
You
there?
need to have a legitimate purpose for being here.
I am. I would like to see the captain or the chief.
They are not available. You will not see them.
I will sit here all day and I will come back tomorrow and I'll come back every subsequent day until they see me. You're not understanding. I'm disabled. You have no authority over me. You're not going to tell me what to do. You don't intimidate me. You understand that?
I'm sorry that you feel that way.
So we can get the chief.
I want to be very clear.
Who are you?
I'm
Please
Captain
identify.
Schmidt.
Captain Schmidt. Let's get some.
Perfect.
Perfect.
We are not going to continue in this pattern. You are interrupting the flow of our operations.
You would let me know how I'm interrupting. I would like to know how I'm interrupting.
All of your complaints are
You said I
closed.
knocked on the window and I'm
Listen, because I need you to hear this. All of your complaints are closed. If you're dissatisfied with how they've been dealt with, you can follow up with the Attorney General's office. That is your remedy. If you're further dissatisfied with how you've been treated, you may follow a lawsuit, get yourself an attorney and do that. What we are not going to do is we're not going to have you sit in our front lobby. We have a duty.
You can't do anything about it. You can't do anything about it, Captain Schmidt.
We have a
You
duty
can't do anything about
to
it,
keep this
Captain.
lobby open for the other members of our town to come in and file reports.
You're 100%
for
right.
victims of crime to come in, for people to come in.
Is
and
this
get
a
their
public
police
lobby?
reports.
It is on the onus of you to create privacy. You don't want to
That's
talk to me,
right.
bro. I know
You're
more than you. I know
exactly
more
right.
than you. I know more than you.
I just want you to understand what I'm saying.
Are you going to arrest me if I don't
you
leave? Are you going to arrest me if I don't leave?
Yes. Yes.
You might
I
want to
am.
put the cuffs on me right now. Put the cuffs on me
I
right now. I'm not leaving.
absolutely am.
I am protesting. I am in your lobby protesting.
So I want to be clear.
First Amendment
You have
right.
No legitimate
First
business.
Amendment right.
You are creating a disturbance.
Where?
I have a question.
There's other people.
Those are operations.
One person now. There's one person here. What disturbance?
He's the
He's
the
in your-
He's the
mailman.
mailman.
Okay.
I'm their mailman too.
Yeah.
Right?
He's my
Thank
mailman.
you.
Arrest me or get the hell out of my
How was
I
a
am done.
complaint?
Right now you can stand up. You can walk out.
No, I'm not. So you can arrest me.
You refuse to leave, you are going to be arrested
For what?
How was
I have to break the law in public for you to arrest me.
You are no longer welcome in this area.
Why? I'm First
Because
Amendment.
you're creating a
Is it a
disturbance.
First Amendment
Your
right
cause
to?
is to interrupt the flow of our operations.
How? How? What did I? Okay.
Our front desk lobby is now closed because of your attitudes, because of your actions, because of
They've
your
never
behavior.
been out
The
here.
Yeah, I
dispatchers
asked
do not
one-
feel safe being at the front desk with you.
They're
That's not my
behind
problem. That's not my
glass.
problem. If you don't feel safe, then you should be a cop.
Okay,
Are you buying bullets?
So this is.
Let me
this
ask
is-
you a
this is what it
question.
comes
Let me
down
ask
to.
you a question.
You can leave or you can be arrested for trespass. You are no longer welcome in this
Slap
lobby.
How-
them
That's it.
Slap them on.
How
I want
are
to know
you-
what live.
Stand up.
I want to know what live.
Stand up.
I am
Stand
passively.
up and turn
I'm
around.
passively aggressive. Passively.
Stand up and turn around. You are
Patty,
under arrest
he's
for
twisting my
trespass.
wrist. He's twisting my
You are
wrist.
under arrest. Stand
Okay,
up.
I'm going dead weight. Please don't twist my wrist. You're not stronger than me, bud. You're not stronger than me. Let go of me.
Listen.
Like you're not
Bubs,
stronger than me.
Bubs.
I don't want to hurt you. I don't want you to get hurt.
How can you say?
How are you?
How can you say a complaint was closed that was never filed?
That's what we have here. Number one.
Please stop twisting my wrist. I'm putting my hands behind my back. Patty, see how rough they're being with me?
How can you say a complaint was closed that was never filed? We are here to file the complaint and you're saying it's already closed.
You are under arrest for trespass.
Well, go on, break the trespass. It doesn't matter. I have to break a law. I have to break a law,
And you can
sir.
take that up in court.
Okay. Just like.
You have to wait out here.
That's fine. I haven't gone anywhere.
Captain Schmidt orders Mr. Reynolds to leave the police station, and when he refuses, Mr. Reynolds is placed under arrest for trespassing. Section 140.05 of the New York Penal Law states that, quote, a person is guilty of trespass when he knowingly enters or remains unlawfully in or upon premises. Section 140.00 of the Penal Law defines the term premises as including buildings and any real property, and explains that, quote, a person enters or remains unlawfully in or upon premises when he is not licensed or privileged to do so. A person who, regardless of his intent, enters or remains in or upon premises which are at the time open to the public, does so with license and privilege unless he defies a lawful order not to enter or remain, personally communicated to him by the owner of such premises or other authorized person. As the First Department appellate term of the New York Supreme Court, which is one of the lowest level appellate courts in the state, explained in the 1981 case of People versus Hedeman, quote, even where municipal or state property is open to the public generally, the exercise of First Amendment rights may be regulated so as to prevent interference with the ordinary use of the property by other members of the public with an equal right of access to it. The defendant does not have an absolute right to use all parts of a public building or its immediate environs for his unlimited expressive purposes. The critical question is whether the manner of expression is basically incompatible with the normal activity of a particular place at a particular time. While applying this precedent in the 2008 case of People versus Reap, the Kings County Criminal Court upheld a trespassing conviction against a citizen who refused to depart a police precinct after an officer ordered him to leave. However, the facts of this case are easily distinguishable from Mr. Reynolds' situation. In the Reap case, the defendant insisted on speaking with a Detective Jones, and when he was told that there was no detective by that name at the precinct, he became irate and began to yell and scream. Consequently, the court concluded that the order to leave the premises was lawful because, now quoting, the defendant was unable to give a valid reason for being at the precinct, and, now quoting again, allowing the defendant to stay upon the precinct property would interfere with the ordinary use of the property of the police department and by other members of the public. In this situation, Mr. Reynolds had legitimate business at the police station as he was there to file a new complaint, which had not been accepted at the time he was told to leave, and he was not yelling, screaming, or otherwise posing a potential safety concern or disruption like the defendant was in the Reap case. Accordingly, while Mr. Reynolds did defy an order to leave the premises, he would have a strong argument that the order was not lawful, and that he therefore did not commit the offense of trespassing by refusing to leave.
Start again from the part where you're no longer accepting complaints from my husband.
So, and I would be very clear on this, so there is no confusion. Every time we have an
Wait,
interaction-
I need you to say we
I'm
are
getting
no,
there.
okay.
I'm going to build to that
Okay.
point, so I'm going to say it very articulately,
Okay.
so there's no confusion. Every time we deal with your husband, that is a targeted attempt, in our estimation, for him to complain about our officers. Every time we have an interaction with him, what follows is another complaint. We have adjudicated complaint after complaint after complaint. We are not going to continue to entertain this behavior. We are not going to continue to use our manpower and our resources to focus on one person who is trying to interact with the police to make complaints. We're not going to.
You understand though, if your police were conducting themselves professionally, if they were not calling my husband an if they were not lying to both of us, we wouldn't be in this
So
situation.
there are other avenues for him, as I already explained earlier. He can go to the Attorney General's office if he believes we're not handling these complaints seriously, if we're not investigating them fully. He can file a lawsuit. Those are avenues to him that are legal avenues. Once we're at the point where I say you have no legal purpose in this building any longer and you are interfering with their operations and you need to leave,
Right.
at that point, he had to leave.
Because you came out saying the complaint was filed and closed.
Yeah, so,
But we hadn't
and
even
what we're
filed
not
it yet.
doing is we're not just going to continue to do, okay, that complaint's closed, I'm doing a new complaint. Well, I don't like the way they talk to me, it's a new complaint, it's a new
Well,
complaint. it's a
so
new
here's the issue
It's a
though,
drain
when
on police resources.
I understand.
After Mr. Reynolds was arrested, Captain Schmidt informed Ms. Reynolds that the department will no longer accept complaints from her husband. At the time of writing this episode, the status of the trespassing charge against Mr. Reynolds is unknown, and it is unclear if he intends to escalate his complaints outside of the Cheektowaga PD or pursue a lawsuit against the department. Overall, Captain Schmidt gets an F. for refusing to accept complaints from a citizen, violating department policy in doing so, and likely unlawfully arresting Mr. Reynolds for trespassing. Policy 1010 of the Cheektowaga PD Policy Manual requires that, quote, all complaints will be courteously accepted by any department member and promptly given to the appropriate supervisor. The supervisor, upon contact with the complainant, shall complete and submit a complaint form as appropriate. The policy also states that, now quoting again, a supervisor who receives a complaint directly shall, without unreasonable delay, interview the complainant and conduct a preliminary investigation for the purpose of determining the nature and category of the complaint. And that, now quoting again, it is the responsibility of every member of this department to advance this policy by courteously and impartially receiving and processing complaints consistent with established procedures. Finally, the policy states that, now quoting yet again, the Cheektowaga Police Department shall assist citizens and members to bring forth complaints regarding misconduct, unprofessional and or inadequate police service. Promptly investigate all such complaints in a competent, professional, and impartial manner. Well, clearly, Captain Schmidt's decisions to refuse to accept Mr. Reynolds' complaint, to order him to leave the precinct rather than accept his complaint, to arrest him when he refused to leave, and to bar him from filing future complaints, did not comply with the terms of this policy, and likely violated Mr. Reynolds' Fourth Amendment rights as well. Now, in stark contrast to Captain Schmidt, Sergeant Rutkowski gets an A for maintaining a professional and respectful demeanor throughout the encounter, spending a considerable amount of time attempting to engage in meaningful dialogue with Mr. Reynolds, and demonstrating a solid understanding of the complex nature of the criminal and constitutional laws surrounding police encounters. While Mr. Reynolds was openly frustrated with Sergeant Rutkowski's reluctance to give definitive answers to his many questions, the relevant case law has made it abundantly clear that determinations regarding the constitutionality of officer conduct is almost always highly fact-specific and circumstantial, and I can appreciate Sergeant Rutkowski's hesitance to give an opinion on situations where he was not fully apprised of the facts of the situation and had not conducted an independent investigation. I also want to commend Sergeant Rutkowski for standing firm in his refusal to issue an unlawful citation to Lieutenant Slavatitsky for disorderly conduct, despite Mr. Reynolds' criticism of this decision. On the whole, Sergeant Rutkowski showed a tremendous amount of patience and professionalism, and should be praised for his clear attempts to foster rapport with Mr. Reynolds. Mr. Reynolds gets a B-, because although I strongly admire his tenacity and his commitment to his constitutional rights and police accountability, he demonstrated some misunderstandings about the laws he discussed, demanded certainty from Sergeant Rutkowski in legal gray areas where it could not be given, insisted that Sergeant Rutkowski arrest or cite the officer who cursed at him when he cannot do so lawfully, and insinuated corruption when he refused to do so. Now, while I understand that Mr. Reynolds was attempting to make a point about the discrepancy in treatment between officers and civilians, I find it unsettling that a First Amendment auditor would argue that anyone should be arrested based solely on their use of profanity. The First Amendment protects a substantial amount of speech, including profanity, both directed at and used by police officers, and it is essential for First Amendment advocates to maintain a consistent position on the constitutionality of speech, regardless of who happens to say it. I also notice that while at some times Mr. Reynolds articulated his arguments well, he at other times had a tendency to become aggressive and talk over Sergeant Rutkowski rather than giving him an opportunity to actually answer his questions, and became disrespectful in his demeanor at several points during the encounter, which was particularly jarring when he was incorrect about the legal points he was making. That being said, I do believe that Mr. Reynolds has the potential to become an effective First Amendment auditor, and I encourage him to continue to learn about the applicable legal framework and grow from his experiences. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to pick up your copy of the Civilian Rights Hand Guide in the links below.